What if the very clauses in your custody agreement, the ones you thought were safeguards, could be used against you the moment you set foot in a courtroom? You spend hours negotiating every detail, convinced that each phrase protects your rights and your children's best interests. Yet, hidden within that carefully worded document lie loopholes so subtle that they slip past the most diligent of parents, only to resurface when it's too late. Imagine discovering that a seemingly innocent definition of primary residence can penalize you for a business trip or family emergency. Picture a judge second-guessing your medical or educational choices because your agreement uses vague, joint decision-making language. Envision being hauled back to court over a minor move or branded in contempt for a simple scheduling hiccup. These aren't far-fetched scenarios. They're real pitfalls that have blindsided mothers who believe they'd covered every angle. Over the next few minutes, we're uncovering 5 of the most common custody agreement details that can unexpectedly work against mothers in court. You'll see how each provision has tripped up women just like you, learn the warning signs to watch for in your own paperwork, and discover the exact steps you can take today to seal those cracks before they're exploited. Ready to turn the tables and reclaim your peace of mind? Let's dive in. The term primary residence sounds simple, but in the fine print it can become a trapdoor that swings shut behind you. When your agreement defines one home as the primary one, it often ties parenting time to your physical presence there. That means every business trip, family obligation, or even a weekend getaway can be used as evidence that you're not really putting down roots, and a savvy opposing counsel will leap on any absence to argue for expanded visitation rights for dad. Picture a mother who travels once a month for work. Her flights aren't just travelogues, they become grounds for claiming she doesn't truly live with her children. Even brief hospital stays or helping an aging parent can be recast as abandonment of the primary residence, eroding your custody share without a single heated courtroom battle. Worse still, many agreements don't spell out exactly how much time you must spend under that roof to keep your status. Is one overnight absence a problem? 2. The ambiguity gives judges wide latitude to interpret your schedule against you. And because modifying that language later means another expensive court hearing, most moms simply absorb the loss rather than fight back. If you've ever hesitated to accept a job offer that requires travel, wondered if a family emergency could upend your custody, or felt trapped by a definition you barely noticed when signing, this clause is why. And that was just the beginning. You might assume that joint decision-making means you and dad get an equal say in big choices. But when that phrase is left vague, it hands the judge a red pen to rewrite your life. Agreements often lump education, healthcare, religion, and other major issues under one umbrella, never defining who actually decides what. The moment you disagree, say, over whether your child needs braces this year, wants to switch schools, or should get a flu shot, it can turn into a full-blown court fight. Dad simply points to the lack of clarity and asks the judge to step in, and suddenly your carefully considered plan is on hold until a stranger in robes makes the call. Imagine you've always managed your children's doctor visits and researched every schooling option, only to face an emergency surgery you believe is necessary. You notify dad as the agreement requires, but he objects, citing his right to consent on major medical decisions. Because the clause isn't specific about what counts as major, the judge can freeze treatment or demand another hearing. Meanwhile, your child's care is delayed, stress skyrockets, and your authority as a parent is undermined in an instant. This isn't just theoretical. Lawyers have turned these catch-all clauses into bargaining chips, dragging moms back to court over disagreements that should have stayed at the kitchen table. The more generic the language, the more leverage it gives the other side. If your custody document doesn't list exactly which decisions you control, or when you get to act unilaterally, you're leaving your parental instincts subject to courtroom politics. And if you think tightening that language later will be easy, think again. Modification requests mean expensive filings, lawyer fees, and unpredictable judges. But it gets more complicated when you try to move away. The moment you see a must-approve relocation clause tucked into your agreement, it can feel like a safety net, until it snaps shut around your ankles. At first glance, requiring both parents' consent before you move seems reasonable. It's there to keep everyone in the loop. But in practice, it hands the other parent a veto power over your life plans. Want to accept that out-of-state job offer, or move closer to aging parents for support? Dad can demand a best interests hearing, dragging you back into court to justify every packing box. Imagine a mother who landed her dream position 2 hours away. She notified her ex as the agreement stipulated, only to have him file an objection within days. Suddenly she's knee-deep in expensive lawyer fees, court filings, and travel expenses. fighting just to keep her children within driving distance. What started as a simple request to relocate turned into a months-long legal battle, during which her kids' stability was questioned and her financial cushion evaporated. The clause meant to protect their well-being ended up costing her time, money, and peace of mind. Even worse, these provisions rarely define what counts as a relocation. Is moving across town a problem? What about a temporary work assignment? Judges interpret relocate however it suits the argument on the table, giving dad's attorney endless angles to block your plans. And once you're tied up in court, requesting modifications, or removing the clause altogether, means another round of hearings and more legal bills. That mountain of paperwork and uncertainty is enough to make any mother think twice before pursuing the simplest move. And then there's the calendar. Many custody agreements include a ticking clock, automatic review dates, and substantial change clauses designed to keep everything up to date. On paper, revisiting the arrangement every 2 or 3 years seems sensible. Kids grow, circumstances shift, and the court can adjust orders accordingly. But in practice, these calendar-driven reviews become ambush points. A single health scare, a seasonal job shift, or even a child's changing extracurricular interests can be labeled a substantial change, forcing you back into court. You're not just juggling custody. You're budgeting for surprise legal fees and clearing your schedule for hearings you never asked for. Worse, the language around substantial change is almost always broad. Does a minor flare-up of an old injury count? What about switching from a full-time to a remote position? In one case, a mom's temporary move to care for an ailing parent triggered a review. Her ex used that brief absence to argue she was no longer stable enough to co-parent. By the time she proved herself, months had passed, her days with her children were slashed, and her finances were drained. And because modifying or removing these triggers means filing yet another petition, most mothers swallow the risk instead of fighting. You might think a review is simply a formality, but when the calendar flips, it can feel like walking into a courtroom minefield. Finally, the enforcement noose tightens. When you agree to a custody arrangement with strict enforcement and contempt provisions, you might think it's just a formality, a way to make sure everyone follows the schedule. But those penalties can become a weapon, turning the smallest slip-ups into a full-blown crisis. Imagine missing pickup by 10 minutes because of traffic or a delayed school bus. Suddenly you're in contempt proceedings, facing fines or even loss of parenting time. What felt like a safety net quickly tightens into a noose, punishing the very parents who are juggling work, school runs, and childcare. These clauses often include graduated penalties. First a warning, then financial sanctions, next suspended visitation, and they rarely account for real-life hiccups. In one case, a mom was fined hundreds of dollars after a broken-down car made her late. In another, a single missed call to confirm a handoff triggered court fees she couldn't afford. Father's attorneys know exactly how to seize on these rules, using them to coerce compliance or shift leverage in ongoing disputes. When every calendar notification and text message becomes potential evidence against you, managing your daily life turns into a legal tightrope. Worse, contempt hearings aren't quick or cheap. Court dates mean missed work, childcare costs, and lawyer fees that add up faster than you can say custodial contempt. Even if you ultimately prevail, you're forced to defend yourself in front of a judge, portray your own parenting in a negative light, and endure the stress of uncertainty. Meanwhile, your children see you under fire for a simple scheduling glitch. The emotional toll on both you and your kids can be harsher than any financial penalty. If your custody agreement includes harsh enforcement terms, it's time to push back. Negotiate clear grace periods, reasonable definitions of on time, and alternative dispute methods like mediation before contempt. Because when the rules are too rigid, they stop protecting families and start tearing them apart. So before you sign, and before you find yourself in contempt, make sure the penalties are fair, flexible, and built for real life. Now that you've seen the 5 hidden pitfalls, from primary residence loopholes to harsh enforcement clauses, take a moment to scan your own custody agreement. Do you spot any vague definitions that could be turned against you? Are there review dates or relocation rules that leave you vulnerable? Remember, these aren't just legal buzzwords. They can reshape your daily life and your bond with your children. The good news is, you don't have to accept these traps as unavoidable. Talk to an attorney about tightening the language, inserting clear grace periods, and defining exactly who decides what and when. Insist on realistic enforcement terms and consider mediation clauses that keep minor disputes out of court. By closing these loopholes now, You'll protect your rights and give your family the stability you deserve. Thank you for sticking with me today. I'd love to hear from you. Leave a comment below and share which clause surprised you the most or one step you plan to take to safeguard your custody agreement. If you found this video helpful, please give it a thumbs up, subscribe, and hit the bell so you never miss our deep dive guides. Your support helps us keep bringing you the insights you need. Thanks for watching, and I'll see you in the next video.